Morning. This is Robert Shapiro at Thomson Coburn. With me is Tyler Black. We will start this presentation in just a couple of minutes. I am seeing people that are still logging in, so I'll give it another minute, and then we'll go live with the presentation. Thank you. Good morning. This is Robert Shapiro with Thomson Coburn. Thank you for joining this webinar. Before we get started talking about country of origin, actually one of my favorite topics, I have a couple housekeeping items to go through. So first, if you have any questions during the webcast, you can submit them during in the question and answer widget at the bottom of your screen. I'll try to answer these, or Tyler and I will try to answer these as we go along, and any others we'll hit at the end. And if there's things that need a more full response, we can do that through an email if necessary. A copy of today's slide deck is available on the resource widget. We encourage you to download it for future reference. You can find additional answers to some common technical issues located in the help widget at the bottom of the screen. Quick tip: if your screen freezes or you encounter other technical issues, pressing F5 will refresh the screen and fix most problems. If you continue to have problems, please send a note using the Q&A widget, and our staff will assist you. This webinar is CLA accredited in California and Illinois for 1.25 hours of general CLE credit, and in Missouri for 1.5 hours of general CLE credit. We award CLE based on attendance for the entire period of the webinar. That's 75 minutes. From time to time, you'll be required to click a pop-up screen to reflect your continued engagement. We appreciate your participation in the course. So now, without further ado, we'll get started on discussing some issues of country of origin. This has been a hot topic of late because for a lot of reasons. One is the changes with regard to USMCA. The second one is some changes with regard to Hong Kong and China. Third one is the China duties and the determination of origin for the China duties. So it's been a hot issue, and we'll go through each of these. So here's a brief agenda. We're going to talk about why country of origin is important to begin with. What is a country of origin? Free trade agreements, the idea of substantial transformation, which is where we'll spend most of our time during this webinar, and then some points on some recent developments. So, the origin requirement. It's interesting to see where this comes from, and so the origin is required as part of the general statistical notes in the harmonized tariff schedule, which require the reporting of the country of origin of the goods expressed in terms of a designation of their country code as listed in Schedule B of the tariff schedule. It also is required under the marking rules of the United States, and in free trade agreements, it's also required under those provisions. So there's several different aspects of country of origin where it's required, but for the entry and for filing good and reporting goods upon importation, this is our primary basis. So why is it important? Well, the country of origin determines duty. If anyone's looked at the tariff schedule, you'll notice that there's several columns for duty rates. One is column 1, which is the most favored nation duty rates. The second is the second column, column 2, is for used to be for communist countries. We don't use it very much for most countries right now. Cuba and North Korea get treated to that if you're able to bring anything in from those countries. So column 2, and we need to have country of origin for that, but it's also for preferential treatment under free trade agreements, and it's also for trade remedies, ADD, CVD, 301, other trade remedies. We have to determine the origin risk assessments for cargo security, statistical data that the government collects, and that statistical data becomes very important in trade negotiations. So when we negotiate a trade agreement, being able to understand the value of trade between the United States and another country is important, and the only way to be able to do that is by collecting reasonable country of origin information at the time of import. And it's material. The courts have found that a false statement with regard to country of origin is a material omission or material false statement and is subject to penalties. So it really, and that's even if it didn't impact this duty change because of the importance of understanding the country of origin just for the collection of statistical data that the government may use. So it's considered material and important to the government and is subject to penalty, record keeping, and all those other provisions that apply to material information. So let's start with a basic idea of what is a country of origin. So a bit of background, I was once having a discussion with a staffer at the House Ways and Means Committee on a trade issue, and the staffer looked at me when we were talking about country of origin and said, you know, that's almost existential. And in a way it is. It's the country of origin is where a thing became the thing that it is. And that's what we're trying to determine, and there's a whole legal structure into trying to define what is a thing, its thingness. So the country of origin is the country of manufacture, production, or growth of any article of foreign origin entering the United States. Well, that only invites more questions. So what is this specifically with regard to manufacture and production? What does that mean? And that's what we will spend the rest of this webinar discussing. So the general proposition
and Robert,
is a good...
Sorry, Robert.
Yes.
If I could just interject very briefly here, I see a number of you have asked about whether you can download the presentation, and there may be an issue doing that. So we're having our staff sort that out. So we'll let you know when the presentation will be available for download. Thanks.
Thanks. Thank you, Tyler. So the general proposition is a good originates in the country in which it is wholly grown, produced or manufactured. So wholly grown is really, we're pulling it out of the ground, we're mining it. Those are things that are, you know, fisheries, et cetera, that's wholly grown. But then the production and manufacture becomes the bigger issue for most of us. So what's production and manufacture? We're getting into a little bit more detail now. That's where all foreign components have been substantially transformed into a new and different article of commerce with a name, character, or use, and actually it's sometimes and use, and most times now it's and use from the court, distinct from that of the article or articles from which it was transformed. That's going to be the latter part of this presentation. That is a big mouthful, that second bullet point there, but it is, what is this substantial transformation all about, and how do we get to it, and how do we think about this and give it parameters that we can work with? Otherwise, we have another one, is the processing meets another statutory requirement. We'll talk about that in the upcoming slides when we're talking about free trade agreements, where we've come up with another mechanism, a different mechanism for determining origin. So when someone wants to know the origin of a product, my first question is, why do you want to know? And that's important, and that's becoming more important in recent case law, is to think about origin in terms of the reason for knowing origin, because we have different rules that apply depending on the purpose of the origin. So under free trade agreements, we have preferential rules of origin that are, in most cases now, not in all, but in most cases are based on this concept of tariff shift, which I'll talk about. In terms of marking, all items that are imported into the United States must be, of foreign origin, must be marked with their country of origin. And in terms of marking, we use the substantial transformation test, which we'll go into. Except under the NAFTA, where we use the NAFTA marking rules of origin. Some of you may be thinking, wait a second, Robert, Didn't NAFTA go away July 1st, and now we're under the USMCA? And my answer to that is absolutely. And it's uncertain now. Right now, the USMCA does not require the use of separate marking rules. Customs right now is sticking with the NAFTA marking rules of origin for goods from Canada and Mexico, but there's a lot of uncertainty how that fits. So I would say we're looking at, for marking, you really, for under USMCA, you really want to look at both the NAFTA marking rules of origin and the substantial transformation test and figure out how that marking is going to be, and there may be a need to request information from Customs to make a determination. Then textile and apparel have separate rules of origin that we use under 19 CFR Part 102. Entry declaration, another purpose for marking, for country of origin. We talked about that with the statistical reporting requirements. So entry declaration, generally based on substantial transformation. The exception is the NAFTA marking rules of origin, which now, since NAFTA is expired, don't generally apply, except maybe, well, except in a 520D situation. And now we're stuck in the same position with regard to USMCA because Customs right now is sticking with the NAFTA marking rules of origin, but that may change over. May go to substantial transformation. In some ways, I think for the trade, for everyone who is involved in import operations, it would certainly be easier if they if Customs adopted substantial transformation as the general rule of origin for marking and for entry declaration. That would certainly make things easier, because right now under USMCA and NAFTA, you're doing several analyses to try to find your origin. You would still have that if you're using preferential treatment, but that's a different story. Government procurement uses substantial transformation of sorts, and it depends. There's several different rules of origin applicable to government procurement. There's the Buy America Act, the Buy American Act, and there's the Trade Agreements Act, and there's other provisions as well. They use, some of them, like the Trade Agreements Act, specifically uses substantial transformation. Others use it in terms of defining manufacturer, may use substantial transformation, or may use another test to determine origin. And finally, trade remedies, which I mentioned before, ADD, CVD, 301, others, is a substantial transformation test. Interestingly, in the ADD CVD situation, the substantial transformation test will be applied by the Department of Commerce as opposed to Customs, and may come up with a different answer than Customs does. So we have all this conflict occurring just around origin. So on free trade agreements, why do we deal with origin at all? And I like this slide because it shows, you know, the world as in terms of these trading blocks. And when you think about a free trade agreement, the free trade agreement is let's say the USMCA or CUSMA or TMEX, depending on which country you're in. But the USMCA, we've negotiated an agreement, and the deal here is that goods from the trade agreement partners from Canada, Mexico, or the United States will be freely traded with each other. So as soon as we say that sentence, the goods of Canada, Mexico, and the United States will be freely traded between each other, we have to define what those goods are. Otherwise, it would just encourage the circumvention. You would just ship goods from China or someplace else into Mexico, Canada, US, and then trade it between those countries on a duty-free basis. And that's not the intention of the free trade agreement. This free trade agreement is intended to benefit the parties to the agreement. So as soon as we enter into a free trade agreement, we have to deal with the concept of origin, and we have to understand what origin is, and one of the central elements of any free trade agreement is its rules of origin. So we'll look at the NAFTA, we'll also look at the USMCA in this presentation. But we're not going to go into too much detail on them, because if we did, we would never get to what I think is actually a little bit more complex and perhaps even more fun if you are a trade geek, and that's substantial transformation. So under the NAFTA, there's two sets of origin rules, as I mentioned, for goods of the NAFTA country. First, we have marking rules of origin, and those are in Part 102 of the customs regulations, and they tend to be a little more lenient than the preferential rules of origin. So there's rules of origin to determine, and there were and still are perhaps under USMCA, or there still are under USMCA right now, two sets of rules, one for marking. So we apply these marking rules to determine how something is going to be marked, and then we have preferential rules of origin to determine whether something is eligible for free trade status under the agreement. So you have to apply both of those to figure out what you're doing. And under the NAFTA, you had this complicated mechanism called the NAFTA preference override that tried to resolve the issues of when you got to one answer applying the preferential rules of origin and another answer applying the marking rules of origin, and yet you had to make a match up. So there was these preferential, and there still is until all trade under NAFTA is kind of past its time, at least a year past its time. So you had to make those two sets of rules work out. That's gone under USMCA. The governments realized that that was a complexity that was making people jump through some hoops. It didn't necessarily add any real value. The important thing, a couple important things on the NAFTA marking rules of origin, and we're going to see this in other contexts. You may have an item that's required to be marked as originating in Canada or Mexico, even if it's not eligible for duty-free treatment under the NAFTA. That's because the preferential rules are more strict than the marking rules. And the second piece is an item may be required to be marked as originating in Canada or Mexico, but declared as originating in another country for purposes of duty. We've seen that is especially with the China 301 duties. Customs has issued a number of rulings where they've looked at a good under the marking rules and determined that it originates in the NAFTA region for marking purposes, but it also, under the substantial transformation test, it has not, the imported components, the Chinese components, have not been substantially transformed, and therefore it's still subject to China duties, and you have to declare China at the time of importation. So that becomes a complexity that we have to deal with, and one of the reasons that I think customs would be better off if they just use the substantial transformation test for purposes of marking. I will note that customs has hinted that you could have something that qualifies for preferential treatment under the USMCA, or under NAFTA at least. They haven't issued a ruling yet on USMCA on this point, but that originates for preferential treatment under the NAFTA and could still be subject to Section 301 duties. I question that. I certainly question it even more so under USMCA, but to me, I think there is an inherent problem there in that you have an agreement which says, here's the tariff treatment that will be, the goods that are eligible for preferential treatment are subject to. They'll be duty-free under the preferential program, and customs then saying, oh, but we think it's from China under this rule, and we're going to charge China duties. And I think Canada and Mexico would actually have grounds to say that that's a breach of the agreement. That hasn't been decided yet. I'm sure at some point, if customs pushes that issue will be litigated, and we'll see how that works out. I think it's a thing to watch this space for.
And Robert, we have a question
Yep.
that, yeah, I was going to acknowledge that touches on what you just mentioned, I think.
Yeah, so one question, couldn't you then have a different country of origin if using substantial transformation versus preferential rules under the NAFTA, meaning something could be marked country of origin Mexico for substantial transformation, but USMCA rules now be country of origin China on the entry. Don't the entry CO and the marking CO have to be the same? I actually think that's maybe a little bit backwards in that I think the real risk is that you have it originating as under USMCA for preferential, and then also China in terms of marking and in terms of the China duties. And I think that's the point, exactly the point that I think will be litigated. The two, by the way, do not have to match. The entry CO and the marking CO do not have to necessarily match. And we're seeing that particularly in the context of the Hong Kong rules, where Customs has recently stated, because of the Chinese actions into Hong Kong and the reduction in freedom in Hong Kong, that Hong Kong has lost special treatment under Section 1304 of the Customs laws, which is the marking laws. And so Customs issued a notice that said, okay, goods from Hong Kong must be marked as product of China, but on the entry, you're going to declare it as Hong Kong for purposes of the entry. So, and that's Customs' formal position on this, which actually we had anticipated when the executive order came out, but that's how that's working out. So, what we're finding now is that this why do you need to know the origin, and what is the reason you're asking is really important, because we may have these distinctions that we have to deal with. There's one more question. That's just the country of origin file and the resource list is empty, and staff's addressing that. So the next thing is USMCA. So USMCA retains many of the preference rules of origin that were in the NAFTA. There are not a lot of changes to the origin rules. The important changes are with regard to the automotive sector. There are some important changes there, primarily though dealing with regional value content and labor value content. But there are some rules of origin changes to the rules of origin just in the tariff shift approach. And since I just mentioned the tariff shift approach, I'll go into that in a little bit to explain how the origin rules work under these trade agreements. And I'm using USMCA in this presentation, but for many of the trade agreements, the modern trade agreements that the U.S. has, this mechanism may be it's going to be different for each trade agreement, but this overall mechanism, this idea of a change in tariff classification, which we're getting to, is a common element in a lot of the modern trade agreements. And when we get to substantial transformation, you'll see why there was a push for something that was a little bit more objective. But the general rules for origin under the USMCA is goods are originating if they're wholly obtained or produced in the party, and that's called Criterion A. And if you see a USMCA certification of origin or a NAFTA certificate, if Criterion A and you have a machine or something like that, then that NAFTA cert is almost certainly wrong. And that's because this wholly obtained or produced is really talking about something where the atoms came from that country. So we're talking about stuff that you're pulling out of the ground, out of the sea, or it's an animal or something like that that's wholly obtained. It could be, cotton and other fibers as well. But wholly obtained or produced is really, it's grown there. So Criterion B, produced entirely in one or more party using non-originating materials, provided the goods satisfy all applicable rules of origin. So that's when we're getting to the tariff shift, which will be the next slide. But here we have applicable rules of origin. So we say, here's this foreign item, and if this foreign item is a different classification than the finished product, or of certain different classifications than the finished product, then the finished product will be considered originating for preferential tariff purposes under the agreement. Criterion C, very similar to B, produced entirely exclusively from originating materials. You'll notice that looks a bit sort of like a combination of criterion A, which is everything, this stuff pulled out of the ground, and criterion B, which is produced entirely in one or more of the parties. What the difference is, I may have something in criterion C. I may import an item, make a component, or make something with now that thing that was made, let's say in Mexico, would originate in Mexico. And then as a downstream producer, I am buying that thing from the person, or acquiring that thing from the person who produced it in Mexico from the imported components. They're giving me a certificate of origin or an affidavit of origin saying that this item, this widget that I just acquired, originates in Mexico, and I'm using it to produce another item that then is perhaps sold to the United States. So here, if that's the situation, so I'm acquiring all goods that I have certificates of origin for, and I know, and it's for all these goods, it's exclusively from originating materials, then I can use criterion C. You don't see criterion C very much. Actually, you see criterion B is the most prevalent criterion. And I would say that if you're looking at certificates of origin for USMCA and you get A, and it's a machine or something like that, you question it, and I would not rely on that certificate because I think it's on its face probably invalid. If it's C, I question it. It's not necessarily facially invalid, but it does raise questions because that's a harder standard to meet. Criterion D is for just special classes of goods that are partially in sets, etc., and deals with those things. And then criterion E is specified goods, and there's some special provisions for ADP machines and the like. You have to look specifically at the tariff for the list of HTS codes for which criterion E would apply. So one other point is in most free trade agreements, there's this concept of de minimis. De minimis comes from a Latin term, which I would try to say, except my Latin's not that good. De minimis lex. The law does not concern itself with trivia, is pretty much what it stands for. And so if the value of non-originating components under the NAFTA was 7% or less, or was less than 7%, then it was just de minimis. You could ignore them because it was considered trivial. And under USMCA, that was increased to 10%. So there's some additional flexibility in USMCA. But since this is not a webinar on USMCA, we're just going to keep going to origin. So the trade agreements, as I mentioned, a lot of them deal with this concept of tariff shift. And so I'm using here an example of the classification of a motor and the rules of origin for a motor. Motors are classified in heading 8501. And so the first rule of origin for 8501 is a change to heading 8501 from any other heading except from heading 8503, 0035, 8503, 0045, and 8503, 0065. So someone may say, hey, Robert, what is included in headings 8503, 0035, 45, and 65? And I would say that's a great question. Thank you for asking. So 8503, 0035, 45, and 65 are the provisions for stators and rotors. And if you go back to maybe high school physics, but even if you don't, a motor is composed primarily of 2 or 3 components, but the major components is the stator and the rotor, and both of these are electromagnetic components, and when electric current is applied to one, depending on the configuration of the motor, it will turn the rotor. And the rotor then creates mechanical force that can do work. That's the basic essence of a motor. So this rule says that the rotor and stator, when you break down the tariffese, the legalese, to English, it says that for a motor to originate in the USMCA region, it must, the rotor and stator must originate in the USMCA region. Really simple rule. So it's saying that if anything else can come in, so the casing, for example, could come in from another country and not affect the origin of the finished motor. The wires and things like that could too, but the rotor and stator have to be produced in the NAFTA region. So that's the first rule. That's a strict tariff shift. There is an exception or another rule. And the other rule is, okay, so you make it from, it goes to 8501, which is the motor, from from tariff items 8503, 0035, 45, or 65, whether or not there is also a change in classification, provided there's a regional value content. So that means what they're saying there is you can import the rotor and stator or both, and make the motor in the NAFTA region. And if the value attributed to the NAFTA productions is 60% based on the transaction value method or 50% based on the net cost method, it will still originate. So there's two sets of rules, and you can pick out which one you use. Generally, you really want to try to stick with the tariff shifts, but you can't always. So you have to do the costing analysis or the transaction value analysis to get to origin and making sure that it qualifies under the NAFTA. The transaction value method and net cost method are similar but different. The transaction value method, we look at the value, the price paid or payable, transaction value, the price paid or payable for the goods when sold for exportation to the country of importation. So that's our raw materials. We look at that price, and we look. Actually, let's start this way. We look at the price paid or payable for the finished product when sold. We subtract out the price paid or payable for non-originating materials to get to what the value essentially is of the originating materials. And we divide by that total transaction value of the finished product. That gives us a percentage. If that percentage is greater than 60%, then we're going to qualify. The net cost method is the same thing, but instead of using transaction value, and there may be instances where transaction value is not available, again, a different presentation, we can talk about customs valuation. But if transaction value is not available, let's say it's a maquiladora operation under Mexico's IMEX program, where there's not really a sale for export to the United States because the U.S. party already owns all the components, we would have to use something like the net cost method, and that would be looking at the cost of the components acquired and the cost of the finished item under the rules of the tariff schedule. If anyone has any questions, please ping me on that. I know that can be a little complicated to understand. There is a question. If we in the U.S. bring in an item from TR and 49% originating content, we do not meet tariff shift because the material that imparts the essential character is TR, i.e. 51% of the value. And we do not meet RVC. What is the country of origin? Is it still TR or is it the U.S.? Look at that again. If we, the U.S., bring in an item from TR. Well, first off, we've got to, trying to think of, from Turkey. There's not a free trade agreement. So we wouldn't be using regional value content for this. It would be a substantial transformation analysis. If we're dealing with a free trade agreement country, then we may be using the regional value content. But the basic answer to the rule, to the question is, if there's not a tariff, if the item doesn't qualify under the rule of origin, either tariff shift or substantial transformation when we get to it, then the origin of the finished component, the finished item, is the origin of that component that imparts that essential character. Or in some cases, if it's all the components, as we'll talk about in a case later on, it's where those components came from. I hope that answers your question. But the point of this origin analysis is we're trying to get to a change in origin by that manufacturing process. The default is whatever origin we had for the imported components, the components that were used in the manufacturing operation. And if there's not a change, either by tariff shift or by substantial transformation, then the origin remains the origin of that component. So, since I've been hinting at substantial transformation, it's time to talk about it. I think substantial transformation is a rule that only a lawyer could love. It is built around argument. There's not a lot of certainty. You have to look at all the facts and circumstances to come up with the answer. So it's a challenging area of law, and it's a lot of confusion surrounds it, including in the court. So this is a case that was decided just this month, and the case will go on, but and this is the judge speaking. With 80 years of application in various contexts, country of origin marking, government procurement, voluntary restraint agreements, generalized system of preferences, eligibilities, duty drawback, the substantial transformation test should, one would anticipate, be fairly straightforward to apply. It's not. Basically, he's saying, look, the law in this area is a bit of a mess. And we're hoping to, by the time we finish this webinar, that we will give you some clarity to work your way through this mess. He goes on. Perhaps the only way to make sense of these seemingly disparate substantial transformation cases is to concentrate on the court's analysis of the underlying statutory and regulatory purposes. So my comment, actually it was before Judge Gordon wrote this, but that the first question when someone asks you about the origin of an item is, why do you want to know? Here's the judges echoing that very concept. So Tyler, I'll turn it over to you to start on substantial transformation.
Great. And before I begin, I've been told that the presentation is now available for download in the resources section. If you're still unable to do that, please pop another question into the Q&A box, and we'll try to address it with you individually. Without further ado, I believe Robert referred to some of the substantial transformation analysis earlier in the presentation as fun. I would probably use the word involved. It's a little bit more accurate in my personal experience. But it is fun in a lot of ways because you really get into the nitty-gritty of the product, the process, and the details of how this good is being produced in one country and how it is being transformed in another one. So the classic principle associated with substantial transformation is a manufacturing operation that changes the name, character, or use of the imported items and results in a new and different article of commerce in the country of importation. That's from U.S. v. Gibson-Thompson from 1940. So that's been with us for 80 years, and we still have the judge's comment in the previous slide about lack of straightforwardness of this principle. So it's always nice to have a guiding principle, but this one is potentially large enough definition to drive a truck through, which is why we're spending half of our remaining presentation mostly discussing this. So how do we drill down on exactly how much is sufficient to constitute a substantial transformation? We've listed some of the questions here that might start some of the fact gathering that will be necessary to make an informed analysis. Do the components have a predetermined end use prior to the transformation in the country of importation? Do the imported items remain identifiable after the manufacturing operation in the country of importation? Do the imported items already impart the essential character to the end item, or is that essential character formed after importation? And a lot of these situations involves some sort of assembly process. Is that assembly process after importation sufficiently complex? How complex is it? Does it meet that threshold of substantial transformation? So in many cases, this is a fact-intensive review of whether individual parts lose their separate identities and become integral parts of a new article, or whether their identities remain. So this determination is really made on an individual product and case-by-case basis. To sort of summarize the thrust of this slide, to determine whether a product was substantially transformed in a country, and by extension, whether it has a new origin, you have to conduct a fact-intensive review of whether the individual parts lose their separate identities and become integral parts of a new article. Let's see here. So here are some factors that are guiding in terms of the analysis. Does the item already at importation have the shape or dimension of the final product? I found that this is a factor that is often of great importance to the final analysis, even though you can't say, yes, it has the shape, therefore there's no substantial transformation. It's certainly not that simple, but it is a good starting point for pegging some of the rest of your analysis. Does it already have the essence of the finished good when it is imported? Part of that, the analysis is also examining what operations are performed pre-importation and post-importation, and then comparing those operations. Where is the more complex process performed? Where is the greater number of parts added to the overall finished good? What steps are involved? How complex are these steps? Comparing the number of steps and the complexity of the work is important. How sophisticated are the operations in each location? What kind of training or education does the workers have to have in order to perform their task? Comparing those between the two locations is also often important. And what kind of just raw cost investment is there in the two locations? Is one a $1 operation and one a $30 and the other a $30 operation, or are they both similar? And that leads into kind of where the most value is added. None of these are dispositive, but and in fact, often there are conflicting factors. You might have a sophisticated operation in one location, but more parts are kind of added and put together in a different location. You have to find a way to look at that holistically and determine whether there has been a substantial transformation. And Robert, I'll toss it back to you for this example.
Great, Tyler. First, we'll go through. You already went through some of these factors, but we'll go through this a little bit further. There's some debate within the court and customs right now is whether we're dealing with this component by component analysis, or whether we are looking at the essence. And sometimes these get combined. What gives it its essentialness, its essential character? So Yeah, I like the use. I love the word essence because it's really actually, as someone noted in a comment, nebulous and hard to define, and that's why this cases go on for a long time. I also want to point out this idea of does the item have the shape or dimensions of the finished product is important because what we're dealing with, again, that may go to the essence, it may go to the character as we break this down, but in its simplest terms, I had a discussion with someone about this just yesterday. In its simplest terms, if your customs officer opens a box and he sees an item and its basic shape is given by a number of parts, the first impression is, well, where did those come from? And is that the same place that you're declaring your origin? So you have to kind of overcome something if its basic form is shaped by certain components. One example, and one of the things actually that is that substantial transformation works well for, although all the origin tests do and they're trying to deal with, is this idea of the flow of commerce. So we have something manufactured in China, further manufactured in Malaysia, and then imported into the U.S. If the substantial transformation does occur in Malaysia, to each of the components that are imported in Malaysia, the country origin is Malaysia. But that's back to the question that was asked earlier. We have to be looking, in some cases, to each of the components. Were they substantially transformed? If there's an item, a component that is used in the manufacturing that was not substantially transformed, then the origin of the product reverts back to the previous place, which is China. So this is particularly important with the China duties. And let's take, because I've seen a lot of this with regard to Mexico, let's take something that went to Mexico, was further manufactured in Mexico. Maybe a lot of value was even added to Mexico, and the classification changed. But it was determined one way or another that even with that value added and the change in classification, the item was not substantially transformed. So that means this finished item, this item that was assembled and put together in Mexico and has a new classification from the item from China and has a greater value than the item from China, is considered to be originating in China, and that total value could be subject to the China duties. So this is a big thing because now you have this value being added along this supply chain, and if it's not a substantial transformation, that value is adding to those China duties, even though that value was added in a country other than China. So Tyler, back to you.
So take this case. This is an example of forging, and this probably most clearly hits on that first bullet point from slide 17 back here. Does the item have the shape or dimension of the final product? So what we had in this case, which is a 1998 ruling, was German steel forgings were formed in the shape of finished surgical instruments, but were not yet finished. They were then imported to Pakistan, where a number of processes were performed on these items. They were milled, assembled by welding, bent in some areas, ground, filed, hardened, annealed, polished, and underwent some additional surface etching and cleaning. So were these processes in Pakistan enough to constitute substantial transformation that would make the origin Pakistan? The answer was no. And Customs cited to a couple of kind of bellwether cases for their determination. They looked to the Uniroyal case for the proposition that if the post-importation manufacturing or combining is merely a minor one, that leaves the identity of the imported article intact, a substantial transformation has not occurred. And it reviewed the reasoning in the national hand tool decision, which will be one of our examples later in the presentation, to conclude that once a forging attains its essential final shape, it is not substantially transformed by finishing operations in another country. And I've seen this in other rulings that have kind of distilled some of these other finishing operations to merely taking away bits of metal or material by scraping or minor bending or grinding or milling, shaving, things of that nature generally are not considered to alter the shape in a significant way. So for these surgical instruments, the lengthening, bending, shaving was not extensive enough to constitute a substantial transformation of the forging. But the facts had to be examined. You had to look at how much was done, what is the before, and what is the after.
One of the other factors that's important in this, as Tyler alluded to, is if you have a forging that can then go into becoming multiple different products, we're more likely to get to a substantial transformation because it's not already dedicated to the specific end use, which we will go into a little further in a minute. Real quick, we know there's a problem with the downloading. One person reported that they rejoined the webinar and was able to download, but I would say don't worry about that. We will email out we can email out the presentation to everyone at after this is concluded. Tyler.
Great. Okay, so example 2. Wire rod to wire after importation. Was there substantial transformation? So Spanish wire rod was subjected to a drawing operation in a different location in Canada to produce a wire. Was that emerging wire, which was stronger, rounder after the drawing operation, sufficient? And the answer was no. This one kind of, it's helpful to go back to name, character, and use. So we do have a name change, wire rod to wire, but the cases are fairly clear that a name change alone is not significantly compelling. So what about the other two components? The strength characteristic is something inherent in the wire rod, which was the item that was imported. Drawing it doesn't substantially transform this into something else entirely. And the end use of the wire rod is generally known beforehand, before that rolling stage. And so you can look at the wire rod and you can have a good idea of what the end product is going to be. So this gets to what Robert just kind of mentioned. Oftentimes you get a hint by whether or not the imported product has a predetermined destiny, if you want to think of it that way. That's a little dramatic, but has a predetermined destiny when it's imported to be this finished good. And then if it does, then that should give you pause if you're reaching a conclusion that there has been a substantial transformation. Again, it's not dispositive. You have to go through, balance all these factors, but it should kind of give you some caution if you're going against the current on that. Let's see. Okay, so example 3. This is the national hand tool case. So we have hot forged or cold formed components that were imported into the U.S. from Taiwan. And the items shaped in Taiwan or were shaped in Taiwan or the U.S., depending on the item. So in the U.S., regardless of where they were shaped, the items underwent these other processes, heat treatments, oil quenching, temperament, and other processes that strengthen the steel. So then you have some other finishing operations that occurred and assembly. Were all of these additional processes enough to constitute substantial transformation? The answer was no. And I think the most interesting thing about this example is that the court differentiated between a process that merely changes the characteristics of a material, in this case metal, versus a more significant process that alters the character of the overall article. So there's kind of a zoom out that the court wants you to take to look at whether the character of the article has been significantly altered rather than the characteristics of the material. So for courts to find a change in character, there often needs to be substantial alteration in the overall article and not just kind of an individual material component thereof. So we go back again to ultimately you can go back again to whether or not the use of the imported items was predetermined at the time of importation. In this case, when they were imported in their shape and condition, they were predetermined.
Tyler, we have a couple questions here. Sure. One is, how strong typically is the intent of end use of the product in the overall analysis? And I think I can't quite answer that question because I think the intent is of the end use. It all goes together with the other factors. But I will say, if you have something that has characteristics or has a character that is in, and I want to distinguish the two from because of what Tyler just said, and the court said in National Hand Tool, but if you have something that has elements of the character of the finished product, and it's clearly then going to be for that end use, it's very strong in the overall analysis. It will shift it. If it's something that is going to be intended for an end use, let's say I buy steel plate and I intend to use it to make an automobile, that's the personal intent or even the corporate intent to use it in this manner does not change it, because that thing's going to be substantially transformed into the automobile. So it really depends on, it's one of the factors that goes with everything else. Next question, is there a general hierarchy of these tests? Name change, variety of end use, manufacturing complexity, labor value, education, physical change, identifiability, etc. Do you have some yes substantial transformations analysis? And we do have some yes analyses, but the problem with the hierarchy, there really isn't a hierarchy, and that's really what Judge Gordon was saying. This is a totality of the circumstances test, which means you really have to look at all the factors to try to figure out whether you're going to have a substantial transformation.
And I'll just add that there are a few cases that say that a name change is perhaps the least compelling of these, but it is still relevant.
One more question, and then I'll get to this next slide. Isn't substantial transformation easier to determine if you just apply the NAFTA marking rules? I understand you may not be qualifying a good for NAFTA, but at least the rules are less subjective. there are two different standards: substantial transformation and the NAFTA marking rules. So, and the courts actually have decided this, that they aren't equivalent. Customs originally, when they proposed the NAFTA marking rules, had intended to use those to get rid of the substantial transformation test, and they lost that case. So they're really different analyses. And what we've seen, even with the NAFTA marking rules, in the NAFTA environment, is we have something that could qualify as originating under the NAFTA marking rules, therefore be marked made in Mexico, but not originate under the substantial transformation test and therefore be subject to Section 301 duties, because this had to do with China. So unfortunately, you can't do that. I say the NAFTA marking rules will give you a good Applying the NAFTA marking rules will give you a good hint, but they do not answer the question. So this next example is really, in some ways, the culmination of all these other ones. And this is a relatively recent case. Had to do with Energizer. It's called Energizer battery, but had to do with the production of flashlights. And in this case, there were more than 50 components produced in China and sent to the U.S. for assembly. So that's a lot. And the assembly process took about 7 minutes and used 2 different workstations and soldering and putting things, the lights inside and all those other steps. And the question was, is this a substantial transformation? And I think this case, when it came out, surprised a lot of people, and I think is still a bit surprising and hopefully is on the outer limbs. But the court found that there was no substantial transformation. And first they dealt with the change in name. And the court, and this is interesting because of what Tyler just said, the court said the issue is not whether the plaintiff imported 50 flashlights, but rather whether the plaintiff's imported components retained their names after they were assembled into the flashlight. Now, I was at a Court of Customs International Trade Bar Association meeting, and someone said, "Wait, so then a car would originate, at least under that portion of the test, wherever the steering wheel is made, because the steering wheel, you didn't import a car, you imported a steering wheel, but the steering wheel retains its name as a steering wheel after it's been put in the car." So I think but that wasn't all the court relied on. This is also important. When assembly operations were manual or required some skill and dexterity to put the components together, but the name of each article and the form and character of each component remained unchanged, the use of the imported articles was predetermined at the time of importation and no substantial transformation occurs. So what the court says here, and they say it a couple times in this case, is that assembly without more is hard to reach substantial transformation by mere assembly without more. That's the take home. One of the take homes from Energizer battery, and the question then becomes really, well, what is more if it's hard to reach it without more? And we'll talk about that more in a bit. But my take is usually some production of components as well as the assembly is where I will come down on a lot of these. The proper query in this case is not whether the components as imported had the form and function of the final product, but whether the components have a predetermined end use at the time of importation. So now, and this may be an exceptional case, and it could be exceptional because that while there's 50 components, something like 19 of them were fasteners. So the court, says, well, doesn't really mean much, except to mean that it really is just an assembly of now, instead of 50 components, an assembly of 31 components. But that's still a large number of components, but a lot of them were fasteners. They said, okay, so it's 7 minutes to assemble, but they had put together a video of the assembly operation for the court, and it was not one of their experienced assemblers doing it because they, took the time to really demonstrate it, and it took 13 minutes to do the assembly under that. And so the court was like, yeah, so maybe it's 7 minutes for an experienced person, but it's only 13 minutes for someone to put it together who doesn't have experience. That can't be that complicated of an operation. But the major component, the major factor, I think, in this case was that all the components in this case, or almost all the components, came from China, and even the wires were cut to size to be used in the assembly operation. And so I think the court looked at this almost like an IKEA bed frame, okay, or an IKEA dresser, where you basically brought in a kit, although this wasn't a kit by any stretch, but you basically brought in all the components used to make it, and then you just did the assembly. And that, just like the assembly of the IKEA dresser, does not result in a substantial transformation or even a change in classification. The court, I think, looked at Energizer battery and the Generation 2 flashlight in that framework. Tyler.
Okay, so here are a few more examples to give some additional flavor to the analysis. From the Uniden America case, there was a question of whether an imported AC adapter that was integrated into a cordless telephone should factor into the analysis. And the court determined that the AC adapter did not constitute or impart the essence of the cordless telephone. There were other items that were more important, and so it disregarded the origin of the AC adapter. In another case, the second bullet point, that's kind of a fun one. A company was harvesting orange juice, producing orange juice, and then concentrating it, and then importing it into a different country, and then reconstituting it, basically taking out and adding back in water. And so it was simply returning the item to what it was, which was fresh orange juice. And so the determination was that the constituting with water in the final location was not a substantial transformation. The essence was the orange juice, not the water being added back in. And the final example is involving shoes. So when an upper and a sole or heel have different points of origin, what is the essence of the shoe? Well, the determination was that the upper of the shoe provided the essence of the shoe. That's what is kind of viewed at. That's what's unique. That's what is the defining component of that shoe. It's not kind of what your heel or your tread is. And every time, if the opposite was the case, every time you resoled or changed out the heel of your shoe, you'd have a different origin on that shoe, and that kind of wouldn't make sense if applied more broadly. That's kind of a nice sanity check on that one.
And Tyler, one of the interesting things in these cases
Sure.
is that, as opposed to a component by component analysis of what was substantially transformed, these cases sort of focus on what imparts that essence, the essential character to the finished product, and whether the imported item imparts the essence to the character. So we have these sort of two competing wings in the customs jurisprudence on substantial transformation.
Yes, I like to think of these as being in the line of touchy-feely cases. So that's kind of a nice box to put that in. Okay, and then kind of bringing things into the 21st century, what about software or things that aren't necessarily physical widgets? Well, there have been some interesting rulings on that. In the Data General case, where you have irreversible programming of, it's called PROM, Programmable Read-Only Memory. It's a type of digital memory. If that is programmed, that changes the pattern of interconnections. And so you have a substantial transformation because you have a completely new use of that item. But programming alone should not be viewed as entirely sufficient. If something is programmed in a country, that country does not become automatically the origin. You have several examples below that where you might not have substantial transformation if there is a rewritable memory, for example. If the programming is merely an enhancement to what was already kind of already formed, then it's not a substantial transformation. It does not add value or complexity or change the use. So it doesn't create a different product. Then it might not be a substantial transformation. A good example would be a case on motherboards. Motherboards are not substantially transformed by a post-importation addition of a central processing unit on the board. This isn't programming, but it's the addition of a unit, a CPU, because it's different from the data general case where the programming functioned to assign permanent use that's different than what occurred before importation. Whereas these motherboards, the use of that motherboard was already determined at the time of importation, was not altered by the addition of the central processing unit. So it all comes back one way or another to name, character, and use.
One of the things I think is really interesting here, and this is one of the really recent cases, the third sub-bullet here. Programming a device in the same country where the software was developed may constitute a substantial. For years, Customs sort of hinted around that, and now they've actually affirmatively stated it in a couple rulings, and so which is, I think, coming into the 21st century also, because it's dealing with this idea of that real value is added where software is developed. But otherwise, the loading of software, I think, is probably, you got to look at it as this also. So you had to do some assembly plus the animating, if you will, software. And the software has to be something that animates and gives the item its real character. So if the item would not be able to function at all until it has the software, and I distinguish that from like a PC where you put a software on and the software could do different things. It doesn't animate it to a specific purpose. So when the software begins to define the item, that becomes important. So a summary of the substantial transformation analysis. So and it's hard. This is really fact specific, and there's no bright line answers, unfortunately. So we have to deal with trying to set up rules around it. So look to the change of form of the item. If the item, as I said before, if the imported item, defines the form of the finished product, you've got a harder battle to get to substantial transformation. Is the imported item subject to machining? And this is different than just finish machining. So finish machining, I'm taking it and just bringing it to its end point. It already had that basic shape, as Tyler talked about in some of the forging cases. But if it's subject to machining that removes substantial material and then begins to give it some definition and some specificity, much more so than the imported item, then I could get to a substantial transformation. So look to machining. Are any of the components that are used in the assembly process manufactured in that place of assembly? And that's one of the things I try to encourage doing, is going, okay, can we do that? Can we at least make some of the components in another country so I can make the origin analysis a little more complicated, and get, especially if I have, like, let's say most of the components coming from China, and then I have some I can make in Vietnam and do the assembly in Vietnam. Well, now I'm going to have a much better chance of saying that this item originated in Vietnam. But that will depend a bit on what those components are that are made in Vietnam. Do they give it its character? Do they give it its shape and its form? Are they key components for how the device operates? So those are the things to look for on that. Are the majority of the components from a single country? That's that Energizer case. I'm going to have a lot more trouble if I'm bringing in all my components, all the major components from one country to another country and assemble them, because Energizer already told me that that's going to be a problem. Can you identify components that impart the essence to the product? And I know I've gotten those comments on essence. Isn't that a fun word? But where was that item produced? And so let's see, what would impart the essence to to the item? It depends on what that item functions as and how it works. I know we're running a little bit over. We've got about 2 more slides, so if you can't stay on, I'm sorry about that, and I'll be happy to discuss this with you. The other 2 are really summary, but we've gotten to the heart of this right now, and if you can hang on, that'd be great. So Tyler, you for the U.S. origin issues.
Sure. So briefly. The statute for marking requires that every article of foreign origin imported into the United States shall be marked in such a manner as to indicate to an ultimate purchaser in the United States the English name of the country of origin of the article. And this actually ties back to substantial transformation, which was a test that was developed in part to help the ultimate purchaser identify where these things are coming from. So the marking statute requires that marking must also be made in a conspicuous place, legibly, indelibly, and permanently, as much as the nature of the article or container will permit. And this is kind of important because the FTC has truth in advertising rules for items advertised to be made in the U.S. Or made in of U.S. origin, that all significant parts and processing must be of U.S. origin. So no or negligible foreign content. So it's very important that the marking is undertaken as a separate analysis to take these truth in advertising rules and the marking statute into account, because sometimes they will be a little bit different than the substantial transformation analysis, even though the end purpose to inform the ultimate purchaser is the same.
I'm often asked, can I mark something made in USA that's going to be sold for export? Because the FTC rules actually apply to items that are sold in the U.S. commerce. And my comment would actually be to use the qualified marking made in USA with foreign components or something like that, just in case these things come back. You don't want to be burned by those. So, and then one of the points that Tyler just said, the marking rules under customs law is every article of foreign origin. So once it's of U.S. origin, it actually doesn't have to be marked at all. Under either the FTC rules or the customs rules. But if it's a foreign origin, it does have to be marked. So it's just to put a fine point on that. And then this idea of the ultimate purchaser. So substantial transformation is the ultimate purchaser is the person who received those goods in the condition as imported. If the item is substantially transformed by an intermediary party, let's say a manufacturer, then that manufacturer is the ultimate purchaser because they received it in the form as imported. A question real quick. In the end, if you can't prove substantial transformation, then do you simply look at the bill of materials and see which country comprises the highest total value of the components? No. You have to actually look to see which components were not substantially transformed, and then you're looking to really see which component then imparts the essence to see what the origin of the item is. You still have to do that whole origin analysis to, if it's not substantially transformed, that just means the country where that processing happened is not the country of origin. That doesn't end the analysis of what is the country of origin. The country of origin is the last place where all imported components were substantially transformed. And if so that's the answer to that question. It really doesn't answer it. The substantial transformation analysis is done to say, does it originate in this country? Now I have to do the substantial transformation analysis to see what other countries may define the origin of the item. Last slide, some final thoughts. First country of origin question, everyone should know this by now, is why do you want to know? Because we really need to understand the purpose of the of origin to understand what the origin is. The rules will change for that, and that's one of Judge Gordon's take home from this recent case, Cyber Power. To do a country of origin analysis, you really want to gather detailed information, map out the production process. I like pictures because, as they say, a picture's worth 1,000 words, and it does help customs if you do that. And if you can map out each step of the production, potentially even with pictures, going, okay, I have this, and this person does this operation, it takes this long to do, and it goes from this to being this, that helps in getting to what you're doing. You really need to look at the process. It is a very fact-specific thing. The more facts you can put together, actually the better. You may not present all the facts to customs if you went to a ruling, and all the facts may not be important, but it's better to have the facts than not. You really want to look at where the components were made also, not just that final assembly, but you look at the whole process. And then, as I said, map out the production steps and make sure you understand them. Analyze whether each component is substantially transformed. And then really come up with a theory of the item. What is it really? And then what part could you really is the most important piece of it? Or parts. There could be more than one, but that really give it its character. So thank you for participating in this webinar. I hope it was useful. Please do not hesitate to ask us any questions. Tyler and my contact information is here. Happy to receive and respond to emails on this. And I hope we got to a point where we give you, at least as confusing as this is, some mechanism to think through origin analysis. Thank you very much, and I'm open to any questions anyone may have. I'll give that a couple of minutes, and then we will close this out. Okay. So no more questions coming in. Thank you very much, and I hope everyone has a good day. Please stay safe, and thank you.
Thank you.